The doctrine of incidental, or ancillary, powers is the legal principle that the grant of a primary power inherently includes the subsidiary authority to perform all acts reasonably necessary to execute it. It is a pragmatic tool for functionality, bridging the gap between written authority and practical action. In constitutional law, it was famously established in McCulloch v. Maryland, 1819, where the U.S. Supreme Court ruled that Congress's enumerated powers implied the necessary and proper authority to charter a national bank. This reasoning has been cited in over 1,750 federal cases and underpins the modern regulatory state, justifying the creation of over 430 federal agencies whose rules impact an estimated 70 to 80% of the U.S. economy. In corporate law, the doctrine allows companies to perform actions incidental to their core purposes, such as leasing property or taking loans. Its adoption is nearly universal. A survey found 100% of Fortune 500 corporate charters include expansive clauses codifying this principle, and statutes like Delaware's General Corporation Law explicitly grant such powers. This prevents operational paralysis, allowing businesses to adapt without constant charter amendments. Here, the principle is flipped. The focus shifts from what power is incidentally granted to what conduct is incidentally or inherently anti-competitive. Courts apply ancillary restraints doctrine to judge whether agreements that limit competition, like non-compete clauses in employment contracts or exclusivity provisions in joint ventures, are permissible because they are reasonably necessary to a legitimate, pro-competitive primary purpose. The U.S. Department of Justice and Federal Trade Commission's 2023 merger guidelines explicitly frame this analysis, stating such restraints are only lawful if they are narrowly tailored and reasonably necessary to achieve a pre-competitive efficiency.